doesn't reach out to anyone. People are brought to him. I mean, he doesn't, like, the people you mentioned that you were going to call a trial, those aren't, some, Pennsylvania Republican official. I mean, that's not somebody who was in the Oval Office communicating with the president.
Well,
fair, right?
Well, with respect to the Arizona Speaker of the House, that is someone the president reached out to. He also reached out to governors. He reached out to the governor of Arizona. He reached out, and again, Republicans, his allies. Our case was a case in which the president was preying on the party allegiance of people who supported him. And these are, again, the record is rife with examples of him reaching out to those people, inviting them to the White House. And another example, sir, is the folks from Michigan. He invited them to the White House. They told him, you lost because you underperformed with educated females. They told him that when he brought them there. And again, our case was filled with examples of that.
Were you planning on calling John Eastman as a witness?
I do not believe we would have, but we would have welcomed if the defense called him.
Okay. It gets tricky, though, for the defense to call him because the people like Eastman and Clark and, Rudy Giuliani and Sidney Powell, I mean, they were shrouded by the special counsel as, co-conspirators 1 through 6. And so they all feared that they were going to be prosecuted if they said anything. Isn't that fair?
Well, they were co-conspirators. I can't get into what was in their mind or not. I can tell you some of the co-conspirators met with us in proffers and did interviews with us. And so the idea that someone like Rudy Giuliani, who sat with a proffer for us, he was available as a witness, and we would have welcomed President Trump calling him as a witness. Boris Epstein sat for an interview with us. We would have welcomed calling him as a witness. Kenneth Chesborough, we would have welcomed it.
Why didn't you charge any of those folks?
I'm sorry?
Why didn't you charge any of those co-conspirators?
As we stated in the final report, we analyzed the evidence against different co-conspirators. My staff determined that we did have evidence to charge people at a certain point in time. I had not made final determinations about that at the time that President Trump won re-election, meaning that our office was going to be closed down.
Right. You've had a 30-year career as a prosecutor. You've prosecuted gang members, right?
Yes.
You've prosecuted organized crime members, right?
Not as much.
But surely one of the fundamental principles of prosecutorial work is you work from the bottom up, and you try to get as many fact witnesses to work with you, and a lot of times those fact witnesses have criminal liability, and a lot of times those lower fact witnesses, the smaller fish, are almost always they're either prosecuted or they are given an immunity because they fear they're going to be prosecuted. But here you didn't, you kept laser focused only on President Trump.
2 points. One, as I said, we were considering prosecutions of these people, and I think I don't want to say what the ultimate conclusion would have been, but that was something that was being considered. The second thing I think to understand contextually is this was a case where the issue was how to present it in a concise way. We had so many witnesses, again, so many witnesses who were allies of President Trump available to us to testify. This was not a case where we needed more witnesses. It was a case where we needed to be able to present the case in a streamlined way because there was so much evidence.
In this book by the Washington Post reporters on page 310, you're familiar with this book. Have you read it? It's called Injustice by Lenig and Davis.
No, I have not read it.
Are you familiar with it?
I have not seen it. I mean, I saw that it came out in the news, but I have not read it.
Okay. Did you cooperate with the book? Did you talk to Carol Lenig or Aaron Davis?
They reached out to my counsel. I did not speak to them.
And did you ever speak with them during your tenure at the Justice Department?
No.
Anyway, they report, and, you know, these are reporters. They get some things wrong. They called Chairman Jordan the chairman of the Senate Judiciary Committee. They said Speaker McCarthy voted in favor of the second impeachment, and I can confirm that it's just laughably inaccurate. And so reporters get things, you know, wrong. And so if that's the case, you know, please flag it. But in the book on 310, the reporters write, as each new tranche of information about fake electors came in, members of Smith's team intermittently raised the idea of opening separate case files on Giuliani, Eastman, and others. Each time, however, Smith dismissed the idea. He said he did not want the office getting bogged down and potentially prosecuting those around Trump. Is that?
I don't think that's accurate. I did make the decision that the first case we brought was going to be Donald Trump, and I was aware that there was evidence against other people, but I don't think that characterization is accurate.
Okay. Now, people with different views than you can say the special counsel's office is only interested in prosecuting President Trump because an election's coming up and he's going to be the Republican nominee. And the special counsel works for a Democratic president. The special counsel works for a Democratic attorney general. And so the special counsel's laser focus on President Trump is simply to prevent him from, you know, either being the party's nominee or being a successful party's nominee, or at the very least, keeping him off the campaign trail. How do you respond to that?
All of that is false, and I'll say a few things. The first is the evidence here made clear that President Trump was, by a large measure, the most culpable and most responsible person in this conspiracy. These crimes were committed for his benefit. The attack that happened at the Capitol as part of this case does not happen without him. The other co-conspirators were doing this for his benefit. So in terms of why we would pursue a case against him, I entirely disagree with any characterization that our work was in any way meant to hamper him in the presidential election. I would never take orders from a political leader to hamper another person in an election. That's not who I am, and I think people who know me and my experience over 30 years would find that laughable.
So did you develop evidence that President Trump you know, was responsible for the violence at the Capitol on January 6th?
So our view of the evidence was that he caused it and that he exploited it and that it was foreseeable to him.
But you don't have any evidence that he instructed people to crash the Capitol, do you?
As I said, our evidence is that he, in the weeks leading up to January 6th, created a level of distrust. He used that level of distrust to get people to believe fraud claims that weren't true. He made false statements to state legislatures, to his supporters, in all sorts of contexts, and was aware in the days leading up to January 6th that his supporters were angry when he invited them, and then he directed them to the Capitol. Once they were at the Capitol and once the attack on the Capitol happened, he refused to stop it. He instead issued a tweet that, without question in my mind, endangered the life of his own vice president. And when the violence was going on, he had to be pushed repeatedly by his staff members to do anything to quell it. And then even afterwards, he directed co-conspirators to make calls to members of Congress, people who were his political allies, to further delay the proceedings.
Did you sought gag orders in both the Florida case and the DC case, is that correct?
We sought an order in the DC case under Rule, I think it's 57.2, And we did that because Donald Trump was making statements that were endangering witnesses, intimidating witnesses, endangering members of my staff, endangering court staff. As you might remember, in the right around when the indictment was released, he issued a tweet saying, "If you come after me, I'll come after you." He called, in a tweet, he called General Mark Milley a traitor and mentioned that what he'd done in olden times, people would be put to death. As a result of the things he was saying, the judge in this case was received vile death threats. And with respect to D.C., both the district court and the Court of Appeals, a panel of judges, found that his actions were in fact causing what we said they caused. They were causing witnesses to be intimidated and endangering people. And I believe it was the Court of Appeals also found that in addition to intimidating or chilling witnesses who existed, it would chill witnesses who had not yet come forward because they'd afraid that they would be next. So yes, we did file that, and I make no apologies for that.
I mean, which witnesses do you think he would have intimidated? I mean, are there any specific witnesses did you identify for the court?
We did a filing. I don't recall the specifics in that filing right now, but as I said, one of the issues from my perspective was not only the witnesses who he had specifically called out and caused threats to be issued, this phenomena that was found by both courts. It was the result of that is that a rational witness who maybe had not come forward would be completely afraid to, because they would see that they would be next. And I think both courts agreed with that.
Well, I mean, the Circuit Court of Appeals ultimately slimmed down the gag order, isn't that correct?
It did, yes.
And what was the difference between the gag order you proposed and Judge Chutkan agreed to, and the final gag order that the D.C. Circuit approved?
Okay, I'm going to go off my recollection. I know one of the differences was him making threatening statements towards me personally was was allowed. I think in the district court in our application, we thought that shouldn't be allowed. I will share with you that I told my staff that it was much more important to me that he not be able to issue threats to court staff and my staff than me. And so the Court of Appeals did narrow it in that way. And as I'm sitting here now, I'm not debating you that they narrowed it. I just can't remember these specific details.
Okay.
But the phenomena, they concurred that the phenomena I'm describing to you today was real.
Okay.
And it had real-world consequences.